You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Hi, welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And excited to be back with you. We are still, we're not going to get away today from this 14th Amendment judicial supremacy clause. We're still having this conversation. And
it's going to be a good one today.
Yeah.
People are going to learn some things.
Well, you can tell, I think, by the last few episodes that we really are focused on the power of the legislature and limiting what the power that we've ascribed over the last few decades to the Supreme Court.
Yeah.
And we've treated the Supreme Court as a lawmaking body.
That's right.
And so we just want to make sure that we get some understanding out there that there's a piece missing to the puzzle.
That there is. and you know what we're getting ready to talk about today on this 14th Amendment, as I pull together some material for us to look at and share with our listeners and our viewers, this will be the classic case of de Tocqueville's statement that if the lights ever go out, they'll dim gradually and we'll be left with wise procedures and no idea why they're there, and we'll make a clumsy use of them. Mm-hmm. And boy, that is what we are doing. So we hope our listeners today go home sad about the education they've gotten, but fired up about what they've now learned and understanding why we're in the mess we're in. And part of our problem is not only do the people not know the things that we're talking about, our politicians don't know, and many of our judges don't know. But the judges who do know and the politicians who do know use our lack of information for their own ends and purposes to our detriment and our freedom.
Yeah.
And boy, if you can't get fired up about that, then I'm going to try to stay calm as best I can today about what we're talking about. It just is maddening to me.
Well,
and I wasn't taught these things in law school, so don't think, oh, you got to go to law school. I didn't learn this in law school. I've learned this over the last 4 or 5 years since the Obergefell case. Now, I had hints of it.
Right.
It's kind of like I have some clue. Maybe there's a God out there, but I didn't know anything about it. But now I'm looking back and I'm saying, oh, now I know why we didn't cover some of this stuff. Now I know why this was vaguely hinted at. Because it takes powers away from the courts and the lawyers and puts it in the hands of the people.
Right. Which we these days tend to appreciate politically the use of the power that we've given the courts. Right.
Yeah, that's right. Yeah. There's actually a great statement. I think I quoted it. Abraham Lincoln, after the Dred Scott decision, I think in 1863, where maybe it's earlier than that, but where the Supreme Court said that ancestors of slaves did not have any rights of citizens, even if they were born here, because nobody intended the Negro race. They were an inferior race. I mean, this is what they said. So nobody intended them to have any rights of citizenship. And so a lot of people wanted to use that, particularly down south. And Abraham Lincoln said, look, we should respect Supreme Court decisions. But when we allow a decision that enters a judgment in private disputes between private parties to set the policy for the whole of the people, we will have surrendered our right to govern ourselves to that eminent tribunal. And then he said, and this will be done for political purposes. So you get a victory in the case of Obergefell versus Hodges or Roe versus Wade, and we treat it as if it's law for the whole of the people. And those who like the result then shake it in everybody's face and says, this is now the law, and the supremacy clause kicks in, and you have to obey it. And that's just wrong, 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 wrong.
Yeah.
But it's believed by our Attorney General. It's believed by attorneys that testified against the Rule of Law Life Act. it's being used by lawyers against the Obergefell lawsuits we have. They don't even know what they're talking about. So before we get into this 14th Amendment issue, people need to understand again, the only power a court has is the power of judgment. Now, they don't mean by that word, I sit here like Cicero and ponder and issue oracles on high. No, that's right. I enter a judgment involving a dispute between you, the abortion doctor, and the state of Tennessee that's passed a bill. Between you, a person who wants Governor Haslam to recognize the same-sex marriage you got in New Jersey, and the governor. I will resolve that dispute. But I do not resolve any dispute as to any other same-sex couples in the state,
or with any other state,
Yeah. And you might say, well, why? This is a constitutional issue. The Constitution says the court only has power over cases and controversies.
So what you're saying is that the court has power to make laws.
No, you got it all wrong. That's right, and that's what we think. So what they're saying is I got a case or a controversy between same-sex couple A and Bill Haslam. I got a controversy regarding abortion doctor A and the state of Tennessee. The court can only enter a judgment to resolve that dispute. It does not extend to any other abortion doctor. It does not extend to any other same-sex couple. Why? Because those other doctors, those other couples are not a part of this case or controversy. So my power can't go there. All I do is enter a judgment. Then what we try to do is we say, well, but the opinion. Well, the opinion is not the court's power. It is their explanation for why they used their power.
For why they made their judgment. Yeah.
That's right. But we elevate opinions for political reasons to say, well, you shouldn't prosecute anybody, or you should do this, or you should do that, as if they've made a policy for the whole of the people. And they have not.
And as if perhaps they're in a different case or controversy that their opinion just might change.
Their opinion might change, and that's happened
it's an
over
opinion.
time. Yeah, that's right. And that's why courts reverse themselves. Our opinion was wrong. Did the Constitution change? No. Just our understanding was wrong. So we got to get that down fundamentally. That's completely lost to these judicial supremacists like James Bopp and Paul Linton and most. Well, I won't even say some other people, but there's some people today that are getting ready to work on a piece of pro-life legislation that are judicial supremacist, and I vehemently disagree with them.
Yeah,
we'll talk about that maybe next week.
And they're playing politics,
but they're playing judicial politics because they see the court as a political body.
They're not worried about what does the law say about this situation and how do we uphold the law.
That's right. They're saying, how do we uphold this opinion, or how do we go about getting them to convince them to change their minds
in today's political arena?
Yeah. So we got to understand that, or we won't understand the rest of this. So,
well, let's mention real quick too why because there's several. I mean, primarily we're concerned with Roe v. Wade and Obergefell v. Hodges, which have created some substantial issues in our country on several fronts, but also, we've put forward that they're straightforward issues of judicial supremacy, of the supposed idea that the court makes laws of the land. And the reason we're talking about the 14th Amendment is because the 14th Amendment has been a really hairy little piece of text that has become the root of both of these issues. In Roe v. Wade, this judgment was based on a right to privacy, perceived from the 14th Amendment. And then in Obergefell, we created an equal dignity clause in the 14th Amendment. So we've done all kinds of funky stuff with the 14th Amendment. Yeah. And as you stated, I think we mentioned this last week, and you'll dive into it today, I know, is that, there's this clause 5 in the 14th Amendment that explicitly describes how we fix or remedy an issue with the 14th Amendment.
Right.
So let's dig into that.
Let's dig into that. So as we know, the abortion.
Because so far we've used the courts to do that.
Yeah, that's right. We've used the courts to do things the courts were not constitutionally allowed to do. And one of the things that's always important, I'm not particularly good at this. You know, when my kids would get a toy at Christmas, I think it was intuitive how to put it together, you know, and so I'd start assembling something and then, oops, where does this part go? Now I got to undo it. I didn't read it carefully, whatever it was. If you don't read the directions, you will mess up most of the time. So what the 14th Amendment does is it says no state shall pass a law that does certain things. Now that is a negative or prohibitory language. It doesn't say states shall pass laws that do certain things. It says you shall not pass a law that does certain things. So one, it's a negative prohibition. It's a prohibition, not a requirement, not a mandate. That's right. And it says so you can't pass a law that it's the due process clause that says you can't take away a person's life, liberty, or property without due process of law. Okay, so for instance, if we were the king, let's say we were under a monarchy, and I said all people with beards starting tomorrow forfeit all their property. Well, you know, where's any due process in that? What are we doing? So that's what due process is. And then there's another thing that says you can't deny people equal protection under the law. Now, all laws discriminate. If you don't hear anything else today, remember that. All laws discriminate. The question is whether the classification or the basis for that discrimination is an inappropriate one. So I was speaking a few years ago in a hostile environment with several human rights organizations there, and I said, we all believe in discrimination. Well, that shocked many of them. And I turned towards the member, I think it was the head of the Metro Nashville area Human Rights Claims Division, and I said, I just watched a great movie about Jackie Robinson. Now, if they had put out in the job description the actor needs to be black, would that be discrimination? I'd say no. The Asian guy may be a far better actor than the one black guy that applied for it, but you really need to have a black guy do this because he was a black man. Nobody would say that's discrimination. So we all believe in discrimination. The question is whether the basis upon which we discriminate is a valid and a right and a good and a just basis. So now let's go, and I want to talk about the marriage issue because this highlights a multitude of problems. It's just, I hate that it's in the gay rights context because everybody stops listening, but it's critical to understand. So we said marriage is between a man and a woman. That's been for millennia. Nobody thought that discriminated, but in fact described what marriage was.
It's just a definition.
It's just, yeah. What is marriage? Well, marriage is a man and a woman. That's what it is. It's like me saying, these are pieces of wood. I'm not discriminating against metal or plastics. I'm just saying that's what it is. And am I discriminating against metals and plastics? No, because that's what it is. So nobody thought it was discriminatory. And every woman, we didn't say only attractive women can marry.
Right.
You know, or only really smart women or whatever. Any woman could marry any man.
And vice versa. Yeah.
Vice versa. So there's no discrimination.
Right.
If we had said something like that, only attractive women or only blondes can marry, well, now you've got, why is that true? Mm-hmm. Okay, but we didn't. So the Supreme Court had always said, well, this is not discrimination. But moreover, they'd said this is a state issue. So unless there's some violation of some equal protection thing, which was the Loving case about race.
Yeah, that's what I was about to say.
Black and white had nothing to do with, the definition of a marriage as between a man and a woman. So they said state law controls. You can decide what a marriage is, but you can't do it on that basis.
Yeah, clear by the 14th Amendment that distinction was a problem.
That's just not an appropriate distinction.
Yeah.
Okay, now, so here we come with same-sex couples, and they say, well, we want to get married. Well, if the court had said, well, the problem is, by definition, you can't. And there's nothing wrong with treating bodies as meaningful legal basis for legal discrimination and biological differences, because if those are not legitimate bases for discriminating or choosing things, why the law would go into chaos. We'd have men and women in mixed cells and being patted down, and we'd have Title IX on women's sports and Title VII and all that. They'd just all be gone. So the court wasn't ready to do that. So they said, well, here's what we have to do. We have to create a right to marry. So where are we going to do that? We will say that it's within the meaning of the word liberty. So now the due process clause reads, no state shall deprive anybody of their life, liberty, parenthesis, what we mean by this word includes but is not limited to two people being able to marry without regard to their sex, comma, and property. Mm-hmm. That's what the word liberty now means. It includes this right to marry. Good. Now we've created a federal right to marry. Now we're going to redefine what a federal marriage is. And we're going to say, by definition, the right to marry that's within the meaning of the word liberty means a marriage without regard to sex. Good. Great. Now we're going to look at the Equal Protection Clause. Since by definition, marriage has nothing to do with sex, a state law based on sex violates equal protection. I mean, that's bootstrapping, isn't it? I'm going to redefine marriage and then say your law violates equal protection.
They really had to do some work to put that in the 14th Amendment.
They had to do some work, but they had to do that work because if marriage is defined as a man and a woman, they would have to say to the gay couple, there's no discrimination here. And we're not going to say sexual orientation is a protected class. We're not ready to say that.
Yeah, they're not ready to say that either.
So consequently, we have to redefine marriage. But if marriage is a state law issue, we can't redefine marriage. So we're going to have to federalize marriage, redefine marriage for federal law purposes, and then tell us your state law violates the federal law. Supremacy clause. Now there it would apply. Mm-hmm. If the federal law defines something some way, that's what it is. So now they've said you have denied people their right to marry without regard to their sex, and your license law, which is defined in terms of sex, violates equal protection. You lose under both clauses, and your state law is invalid. It's unenforceable. Now let's go back again. Here's the problem. The court in the case involving Tennessee ruled in favor of 4 people. It did not rule in favor of all same-sex couples who have come from out of state to here. They ruled in favor of 4. That's all. Their judgment does not extend to same-sex couples who married in California who moved here later, or other people who had moved here during that time, because they didn't sue. The court constitutionally did not have a case or controversy involving any of those other parties.
It didn't have a civil case before.
It didn't have a civil case, a case or a controversy. Yeah. So constitutionally, their power could not go beyond those 4 people.
Or what I meant to say was class action.
Yeah, they didn't have a class action. That's right. They could have filed a class action on behalf of everybody, but they didn't. They also didn't sue a county clerk who issues licenses. Remember, the governor doesn't issue marriage licenses. They didn't have any couples being denied marriage licenses. So the court, and in agreement with the Attorney General, said you can't enter a judgment as to the license laws either. You don't have a case in front of you about that. The court said, you're right, I can't do it. So the question then becomes, we kind of know that state laws like Tennessee's are unconstitutional. Now, Tennessee could say, I'm going to continue to apply my law to every same-sex couple and make every one of them sue me and win. Generally speaking, the state doesn't do that. There's nothing unconstitutional about it.
Right, they certainly could.
They could, because the only judgment they have is for those particular people.
Yeah.
But typically they say, okay, I'm not going to make all same-sex couples sue me to have their marriage recognized. Well, as you can see, the judicial power can't solve this general problem. They can only enjoin the enforcement of my license law as to those 4 people. So if I want to keep applying my license law to all the other people, I'm free to do it. I'll get sued by them all.
And you'll lose.
And I'll probably lose unless
Yeah.
the court realizes we screwed up, but we'll probably lose. So how do you then fix a general pervasive problem? How do you keep Tennessee from not saying, I'm going to enforce my law against everybody and you'll just all have to sue me because the judicial power is limited to a particular case or controversy, particular parties? How do you solve that problem? Well, the 14th Amendment answers that problem.
In Clause 5.
In Clause 5. Now, you have some language here, I think, about Clause 5 from the case of Ex parte versus Virginia, and it's the small case.
I think it's right
Yeah.
here, yeah.
Yeah.
Yeah, so...
Yeah,
Yeah,
read
right
this.
here.
Yeah. Read this to the listener. Now think about it. This is the United States Supreme Court interpreting the 14th Amendment and how you fix problems where the state has a law that takes away the due process or the equal protection rights of theoretically everybody in the state.
Yeah, so it's not that the Supreme Court doesn't understand this.
That's right. They understand it.
We don't.
We don't. We've let them get away with our lack of ignorance and holding it to them. But go ahead. So how do they answer it?
Well, with our proliferation of ignorance, yeah.
Yeah.
It is not said the judicial power of the general government shall extend to enforcing the prohibitions and to protecting the rights and immunities guaranteed.
That's right. And so in the 14th
Speaking
Amendment,
to amendments. Yeah.
it says it's not said that the judicial power is expanded.
Right.
Right. So what does it say is expanded?
It says it is the power of Congress which has been enlarged.
Yes.
Congress is authorized to enforce the prohibitions by appropriate what? Legislation.
Right.
Some legislation is contemplated to make the amendments fully effective.
That's right.
So when the amendments aren't fully effective, when there's an issue, how do you remedy it?
Congress passes a law and says, stop. So let me give you a bad but clear example. The state of Tennessee passes a law that says American citizens of Muslim extraction or Muslim beliefs can't vote because we think you're all terrorists and you're just plotting to take over the world. So we don't let Muslims vote. And Muslims sue, say you're denying me equal protection of the law, you're denying me due process, blah, blah, blah. And so 10 Muslims sue the election commission to be allowed to register to vote and vote. The court enters a judgment, says you've violated the 14th Amendment. These 10 Muslim people can vote. Well, we happen to have 100,000 Muslim people. The state says, I don't care. I'm not going to register any of those other 100,000. They'll have to all sue me 1 by 1 or 2 by 2 or however they want to do it. So the problem is the court sits here and says, well, how am I going to solve this? I can't solve this. I don't have those other people in front of me, and the state's going to keep enforcing its bad law. That's the point of Clause 5. Congress can pass a law. Their power was enlarged, but their power was enlarged to prevent laws. To say any state law that doesn't allow American-born citizens who are of Muslim belief or originally from, can't vote, Congress can pass that law. Now my state law can't work as to everybody. Nobody has to keep suing and suing and suing and suing. I mean, the founders understood how all these pieces fit together, and we have no clue. So
Congress can pass a law, and then you enforce the supremacy clause.
That's right.
And that's where the supremacy clause comes into play.
That's
Not on the judicial decision.
That's right.
But on the legislative activity of Congress.
Right. Because the Supreme Court opinions are not law. Their judgments are not law. The things that are law are the Constitution itself, the acts of Congress, and treaties. So they said, Congress, you can pass a law so that every Muslim, or if it's marriage, every gay couple doesn't have to come along and sue to get the court to protect their rights. You protect it. But here's what the 14th Amendment says. It's to prevent by legislation. So if Tennessee, the only thing Congress could do is pass a law that says, Tennessee, you can't have a license law like this. Okay, they could do that. But that doesn't give anybody a license. It just says you can't have the license law you have. So when the Supreme Court said you had a right to marry, the thing that kept coming to my mind is, well, how do you do it? How do you marry? In the state of Tennessee, you have to get a license. there is no federal common law. The Supreme Court made that clear very back in 1938. There is no general common law right of marriage nationally. They said the only common law that exists is the common law at the state level, whatever your state says it is. So the Supreme Court said you have a right to marry. The question is, well, how do you get a license to marry? And my point was, well, nobody can make me pass a law to license marriage. That actually came up in the Supreme Court arguments, and people blew it off. But the Attorney General from Michigan says you can't make a state license anything. Mm-hmm. So we just stopped issuing marriage licenses. And now people think, well, you can't get married without a license because we think government created marriage, and that's another issue. But the 14th Amendment would only allow Congress to say you can't pass a law that limits licenses.
Yeah, it can't say you must pass a law.
It can't. That's right. Now, well, what are we supposed to do, David Fowler? I guess I need to contact Congressman Green and Senator Marsha Blackburn and ask them to pass the federal due process marriage licensing statute. Oh, we got a problem there. Now, why do we have a problem? There's another case called United States versus Morrison. I think it was in the 2000s or something. And Congress had a situation where they felt like there was, in their words, gender discrimination going on and problems with Title IX and VII, and the states weren't providing adequate remedies. You know, Peyton Manning flips the girl with a towel in the bathroom, and they're not, boys will be boys. So Congress goes out and passes a law that says, no, you really have the right to sue Peyton Manning and sue the University of Tennessee. And so that's what happened in the state of Virginia, West Virginia, I think it was. A couple athletes were treating a co-ed there not well, and was not being handled, she thought, appropriately by the university. So she hauled off and under that federal law sued those ball players and the university under the federal law. Well, everybody said, well, that sounds like a great law. Supreme Court struck it down. They said the problem is Congress has no authority to do this. Now, Congress said, oh, yes, we do. Because of Clause 5 in the 14th Amendment, we have the right to protect people's life, liberty, and property. And they said, no, you dingbats. Didn't you read the thing? It's to pass laws to prevent state laws, not create new federal laws. You have no power to create a federal law. If you don't have it under Article 2 of the Constitution or whatever it is, you can't do it, no matter how badly the states are doing it. So read this question. We've forgotten this point, too, about the power of Congress.
Yeah, so every law enacted by Congress...
Now, this is the Supreme Court you're reading from.
Yeah.
Okay.
Every law enacted by Congress must be based on one or more of its powers enumerated in the Constitution. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written.
That's right. And they quote this old case, Marbury versus Madison.
Marbury versus Madison.
That's right.
1803.
So that's why we say when we use the expression, Congress is a power of limited, the federal government's a government of limited powers, Congress is a body of limited or delegated powers. That's what that means. So you go through the powers of Congress and see where it says anything about marriage or family law. Not in there. Where do you see the thing about prohibiting about giving causes of action for federal lawsuits because people don't treat you well based on gender? Well, it's not in there. But that's where Congress said, oh, yeah, but it's in Clause 5. That's the Equal Protection Clause. We're enforcing that. And they say, no. You can enforce the Equal Protection Clause by prohibiting bad state laws.
Right.
But that's not a power to create a new federal law. So run to Marsha Blackburn all you want for how do I get my same-sex federal marriage license or my marriage license for a marriage defined without regard to sex, and Marsha will rightly say to you, I have no authority over that whole issue. I'm sorry.
Yeah, because it's that positive and negative thing. I mean, it would be a mistake to suppose that Congress has powers only because the Constitution didn't address that particular. Well, the Constitution didn't say anything, so I must have the authority to do it. No, it's the opposite.
It's the opposite.
You only have the power because
right.
the Constitution specifically gave it to you.
That's right.
So if the Constitution didn't give the power, enumerate that power to you, you do not.
You don't get it.
So there's nowhere in the Constitution where it says Congress has authority over marriage.
That's right. So the Equal Protection Clause of the 14th Amendment does not give Congress the power to go around creating laws for equal protection per se and applying them against the states. Now, they can apply them against the federal government, if they want to declare something, they can. But the power of Congress to interfere in the state is only to prohibit the state from doing what it's not supposed to do. That's it. So if that's the case, who can require Tennessee to issue a marriage license based upon a marriage defined without regard to sex? Who has the power to do that?
The Tennessee General Assembly.
If they want to. But they're doing it on behalf of the federal government because the right to marry had to first be in the Due Process Clause to even violate the Equal Protection Clause. And the problem we've got is the Tennessee Constitution says you cannot, as a state, license a marriage that's contrary to the historical understanding in the legal contract between a man and a woman. And if I can't do it for myself, I sure can't do it for the federal government. And in fact, the federal government can't make me issue a license for them because that's called commandeering a sovereign state by the federal government. Can't do it. If you have authority over marriage, if marriage is now a federal thing, the federal government has to do it.
Right.
But there's no authority in anybody in the federal government to do it. They created a right without a remedy.
Right. So let's talk about, just so that it's clear to everyone. So, because we're in a mess.
Yes.
Right? And that's what we're trying to say. And we're trying to say, look, if you actually want this thing to be fixed, here's how you would act. So let's just, so our listeners are clear, because we've talked about, well, the court didn't have the power to do this and Congress has limited power to do that. So if the gay lobby really wanted to fix this thing, that according to the Constitution, and correct me when I make a mistake.
Okay, I will.
What I understand from everything that you're saying is what first would have to happen is we first have to give the federal government the ability to address marriage.
That's right, because they don't have it.
They don't have it currently.
Right.
So in order to do that, we would need to actually amend. We'd need to pass an amendment to the U.S. Constitution,
right?
Specifically giving the federal government, giving Congress the power to address marriage.
That's right.
In the first place.
So under create post offices and roads, post roads, and create coinage and blah blah blah. You'd say and to govern marriage and family law.
Yep. So step one. Yeah. Now, once that has been done, now Congress has the power and the ability to address the marriage. And now Congress has to pass a law.
But they don't have to.
They don't have to, but they can.
That's right.
So now let's say Congress was going to pass a law on same-sex marriage.
Right.
We're still limited. What is it that they can do? They can define marriage federally.
Mm-hmm.
Right?
Presumably, subject to the court saying no, polygamy is now required too.
Okay, yeah. So then we would get into all that.
Yeah.
But we amended the Constitution. We've expanded the government's power. Now Congress has the ability to make a law. They decide, let's make a law. We define and legalize a same-sex marriage in the federal government. Okay.
All right. So
even still, we have the commandeering problem. So Congress has passed a law about same-sex marriage, but now that what they've done is created a federal marriage.
Well, that's right, and they have to license it.
That the federal government now would have to license that marriage.
Yeah, and that's my point today, is they already have to.
Yeah.
I'm not required
and
to
even
issue,
after all of that work,
yeah,
it would still have to be the federal government to enforce their own law.
That's right.
We'd need some sort of a marriage agency.
Yeah, you'd have to go down to like you go to the Social Security office or the veterans, you'd go to the federal marriage office, I guess, and get your license to get a federal marriage. Now, here's the downside for the Supreme Court. If they wake up and realize what they did, is if you've federalized marriage, that means every divorce is now a federal issue.
Yes, they've created family
court and federal district courts.
Whatever.
Yeah. So just like they created bankruptcy courts, they may have to create the marriage court.
Yep, to handle the divorces
To handle all
and
the
alimony
marriages,
and
that's
all
right.
that.
Child support and all that. Now, the Supreme Court, when they realize what they've done, they'll go, egads.
We don't want that.
We should leave marriage at the state level.
Yeah.
But the problem is we defined marriage at the federal level.
Mm-hmm.
And I can't impose a federal definition of marriage on a state law because we're conceding now marriage is still a state law issue. So the only thing is now to say, well, state law marriages cannot violate equal protection. I'd agree. So we can't prohibit a black from marrying a white or an Asian.
Absolutely.
But unless you're going to now tell me that sexual orientation
is a protected
class,
yeah,
you can't define marriage for me. Not in that way. Not as an equal protection.
Which they could do, I guess, if Congress passed something like this Equality Act. I'm guessing that would extend.
No, because Congress can only apply its act to those people who Congress has jurisdiction over, and Congress has no power over the state legislative bodies. Congress's power is over the people, not the states, because we're dual sovereigns. So that there's not an answer there. So if I'm Bill Haslam and I'm looking at this petition that I've got in front of me, I mean, you better be careful. Because if he says, oh, there's a right to marry.
You mean Bill Lee?
Bill Lee, yeah. There's a right to marry in the Due Process Clause of the 14th Amendment. I'll say, fine, that's great, that's good. Then that's the supreme law. It's federal law. And my state prohibits you from issuing a license on behalf of the federal government that's contrary to the state law. So tell Congress to go figure out how to do it. If he says, ooh, that's a terrible solution, why don't I do this? Why don't I argue that same-sex marriage is required because of the Equal Protection Clause? And I'll say, no. You can't really say that because the Supreme Court didn't say sexual orientation is a protected class. And so their federal definition of marriage can't trump a state definition of marriage because you just said state law controls what a marriage is, as long as it doesn't violate equal protection. Well, now here's the other problem you're going to face, Governor. Even if you want to make that argument, nobody requires a state to license anything. And you've just conceded now that marriage is still a state issue. Good, thank you. So my state says you can't issue that license. And then when the governor says, well, how are people going to get married? I'll say, why don't we do it the way we've always done it? Did marriage exist before the government licensed it and people just wandered around like stool pigeons saying, I sure wish I could be married, but I don't know how to do it. There's not a county clerk yet. No. A man and a woman would say, I take you.
Committed themselves.
Yeah, and then I'd go down to the courthouse and say, we got married.
Yeah.
Without
they made a family.
That's right. They made a family. And now, is there any equal protection problem in that? No, because the government didn't create the marriage. They didn't license the marriage. They didn't say who could get married. The common law said who gets married. I didn't make that law. That's a transcendent law that existed before the state of Tennessee ever came into being.
Which the Constitution protects under the Ninth Amendment.
Under the Ninth Amendment. So we've just finished I hope a good show.
It's a complicated issue because it's only complicated because of how much we've forgotten about how our government works, and we're literally having to retrain our brains. I kind of want to close with this because what you said something earlier, and it's like, oh, that's right, that's what they're doing. And I hate to make this. I know as I work at Fact, but I'm very vocal, but I don't like politics. At the end of the day,
I don't like politics.
Oh yeah, who really likes politics? I guess some people do. I don't know.
Yeah.
But it's interesting how we begin to politically treat things outside of law. So again, to me, this is a left-right thing. So you look at what's going on right now with impeachment. I mean, the bottom line is you've got the left that has ideas on policy. You got the right that has, and we are so immensely divided. I mean, almost perfectly in half in this country. And so the left says, well, we can't get this president to do anything that we want to do. So we're going to construe some abuse of power thing and we're going to impeach him, And so you basically construe the Constitution into political action. And that's exactly what we've done in the courts. You look at the gay lobby in same-sex marriage. I mean, it's blatantly obvious to anyone with a brain that you simply do not have a Congress right now that would come anywhere close to passing the kind of legislation that they want to see, right? I mean, much less the ability to pass a constitutional amendment to give them the authority to do so in the first place. So,
Right.
So whenever you can't get your way, what do? Well, we're going to misconstrue the power of the court, and we're going to push our political whims through the court and just make it work.
That's right.
And that's what we're doing right
Sure.
now. We're just playing politics with every facet of our government to get our own ideological way.
That's right.
And what that does, it does great damage to our future because it takes away, and we talked about this like 8 episodes ago. it takes away the liberty of the people, and it puts the power in the hands of the people who have the loudest voices and have the most. What did we call that? The
tyranny of the majority.
Yeah. But I mean, basically,
Yeah.
And that's when we play politics like this. It's what we've chosen to do. We've forgotten liberty, and we've chosen to put ourselves underneath the tyranny of the majority, whatever that majority might be at the time. I mean, even from a conservative point of view, it's like, well, I've got the votes to load the courts with my point of view, so we're gonna use the courts to ram through our policies, whether you like it or not. Well, that's not how this works.
Sure.
So anyway,
but the problem here is they went to the court to get policies they couldn't get at the State House.
Right.
They couldn't get
Couldn't
in
get in
Congress.
Congress.
And they got the court to agree they had a right to marry and forgot about how do you now do it.
Mm-hmm.
And as long as the states are willing to capitulate,
which is all they can count on at this
that's
point.
right. And as soon as a governor says, I'm not the legislative body, I cannot change the language of the statutes, I cannot by myself repeal the state constitution, I cannot enter an injunction against the Constitution, I can only do execute the laws that are in front of me, and I can't do what you want. I'm sorry. The governor could say, I even wish I could. I'd love to be able to do it. But I took an oath to uphold the Constitution. And part of the Constitution is the court doesn't make law for everybody. It makes law judgments in particular disputes, and if we're breaking the law, Congress can pass something to prohibit us from doing it, but Congress can't even make me pass a license law for you. Congress can't even do it because it's Clause 5. Read the directions.
It's good. Hey, as always, continue to invite you to give us your feedback, ideas. You can email us at info@factin.org. But also, David created this really handy little flow chart that really shows the rock and hard place that Governor Lee is in right now with our petition over choosing, how to respond to this petition, and is it a due process problem? Is it an equal protection problem? And it's really some good information. So if you would like that, you can also send us an email at info@factin.org. That's FACTN.org. Thanks for joining, and hope you continue to listen.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.